In fact, what we do is
How about the new
no, it was like this with those elections.
All right, then, Clyde.
Yes, Mr du Plessis.
Thank you, my Lord. My Lord, I'm going to be dealing with three topics, and in some respects I can be obviously much shorter than my predecessors. The first topic is to explain to my Lord why there are no rights that have been shown by the applicants to justify their relief. No rights that, in other words, justify their declaratory stroke review relief, nor rights that justify their alternative interdictory relief. I'm then going to turn, my Lord, to look at constitutional harm, which Freedom Under Law submits has been somewhat glossed over to this point. There are very important features of this case which my Lord would take account of in any exercise of judicial discretion. And related to that, and then the third point, my Lord, is finally the question of costs. And I'm going to be dealing with that in the context of scandalizing statements which have been contained in a media report by the MK party. My Lord, let me start then immediately with the issue of rights. We have listened to the debate, and it really now seems to be common cause through my Lord's questions that the issue is the right to a rational decision, whether that is something the JSC rationally exercised when it decided to refuse the postponement. Lord, we say that the JSC was, Mr Menetje says, correct. We say it was not just rational, it was perfectly rational in doing so. And my Lord, we say that because it had been confronted with a question about Section 178 and composition. That is set out in the letter by MK's attorneys that was written to the JSC in justification for the postponement. And I'll take you there in a second, my Lord. And the response to that was the reasons letter that we've already looked at by the JSC. Again, I'll have to quickly take you back to that. But my Lord, let me just immediately say that in any event, my Lord's point right up front is that all of this is an irrelevancy. This debate around composition is an irrelevancy in light of the fact that it misses the point. Because as my Lord put it, I think it was to Mr Mpofu, the JSC is bound by the brute fact of there being an order of a court. That order of the court, it said that Dr Hlophe is not permitted to attend the JSC's meetings next week. But, my Lord, let me take you down into the debates, because we've had the benefit of those debates a couple of weeks ago in the Western Cape High Court. I can therefore give you, my Lord, an explanation for why what is in the Western Cape High Court's judgment is directly related to this very debate of Section 178. So, my Lord, let me take you, if I may, to the JSC's letter. And that letter is MM5. My Lord, we looked at it earlier.
Yeah.
And my Lord, you'll see that the JSC says that it had an urgent meeting, and it was noted, these are its reasons as we've been describing them. The judgment of the full court did not set aside the decision of the National Assembly to designate Dr Hlophe as a member of the JSC, and does not therefore impact the composition of the JSC. My Lord knows that. Whether it's the question of attendance or quorum or composition, that's how they understood the point. One can have a quibble about whether it's the right terminology in law. It doesn't matter. The point is they understood that was the issue. And then they said the JSC thus remains lawfully composed in terms of, and importantly, my Lord, Section 178 of the Constitution, and there's no violation of Section 171H. They go on to say at the top of the next page, while the full court has interdicted Dr Hlophe, on an interim basis from participating, it expressly found that his absence would not render the JSC's decisions or processes unlawful. So, my lord, they knew that the issue of composition and the interpretation of Section 178 of the Constitution was the issue that they were responding to. And, my lord, it's not the case, with great respect, that that letter was what excluded Dr. Hlophe. It was the court order. That's why they were talking about the court order. The proximate cause is wrapped up with the court order. And we can't separate the letter from the court order. And, my lord, the JSC looked, therefore, at the interpretation and the composition point. We know that from their letter and their reasons. And Mr Mpofu, my learned friend, repeatedly said that this case is about interpretation, and that includes of Section 178. And, my lord, the predicate for his relief, for our learned friend's relief, is that Section 178, properly interpreted, means what? That the JSC is not properly constituted without Dr. Hlophe being present. That is the predicate for their entire case today. And, my lord, our learned friend, Mr Mpofu, said to us that we didn't understand his case, and that the respondents were unfortunately misinterpreting his case. But with respect, we haven't, because if you look at the founding affidavit, paragraphs 82 to 83, I'm afraid to say, my lord, in my hurried printing off, I didn't get the case lines version.
It's all right. Founding affidavit, paragraphs 82 to 83.
Yes, my lord. So here you've seen, just before that, just so that you can go back, you'll see they are saying various things about what their rights are. And here, my lord, you'll see at the top of the page, paragraph 79, they talk about Section 34, then they talk about Section 36, and then Section 19. But here, my lord, is the heart of their case. They say, most crucial, and in addition, the conduct is inconsistent with the clear provisions of Section 178(1)H. More particularly in that, the forced absence of Dr. Hlophe will inevitably result in a major disturbance of the delicate balance intended to be achieved by prescribing that split between members of the ruling party and the bloc on the one hand and members of the opposition parties on the other, and the composition of the JSC as described by the constitutional drafters will therefore, or thereby, have been defeated, which is inconsistent with the relevant provisions of the Constitution. So, my lord, that is their case. They say, most crucially, that's their case. And we've understood their case as that. The JSC understood the letter and the complaint as that. The JSC responded to it by saying, we've thought about it, and even read and we've decided that the meetings must go ahead, even though you ask for Dr. Hlophe to be there. So, my lord, the problem is that for our learned friends, is that the interpretive predicate of their argument today about Section 178 is the same interpretive predicate that was advanced with trenchantly, I may say, and at length in the full court a couple of weeks ago. It was exactly those arguments. We were in those courts. Mr. Mpofu wasn't. He wasn't because the JSC had abided. But I can tell you, my lord, Mr. Bishop and I were there, and those were the debates, the very debates that are now the same debates that are being relied on to animate for the relief sought today. So, my lord, in that context, let me then say that there are two judgments that have been referred to by all of us, which put the debate to rest as to whether it would have been rational for the JSC to consider that interpretational debate of 178 and come to the conclusion that we can't allow him to be there. It doesn't matter if he's not there, it's still composed, and it can still proceed in his absence lawfully. And, my lord, those judgments, the Lord knows, it's the JSC decision, rather the Hlophe decision versus the JSC by His Lordship Mr. Justice Sutherland, Victor and Ledwaba. And Mr. Mpofu read to you, my lord, from paragraph 39. And then you heard from Mr. Mpofu saying that the SCA Cape Bar Council is binding. And we also heard him saying that it has been binding because of its interpretation of the various provisions. But, my lord, the interpretation has been done, and it has been interpreted by the full court, which with great respect is binding on my lord, in relation to these very provisions. And I want to just please with my Lord's leave, read to you paragraph 52 of His Lordship Mr Justice Sutherland's judgment. I can't remember if it was, with no disrespect to either Justice Sutherland or Justice Hlophe, whether it was Justice Hlophe's judgment, concurred in by them. At paragraph 52, and we've heard our learned friend...
Judgment of the court.
Yes, a judgment of the court.
Paragraph 52.
Paragraph 52.
Yeah.
The court has looked at all of these debates, the ski road cases and new clicks, and it's looked at composition and attendance and quorum. But what is the principle of the case? The court comes to express a principle, which is the principle at the heart of this case. It's what Mr Mpofu, our learned friend, says is about interpretation. He kept telling us this case is about interpretation. Well, let's see what the court said. It said at 52. And that goes to our next point, the need to avoid paralysis of the JSC. We are enjoined by the rules of interpretation not to interpret Section 178 in such a way that results in the paralysis of the JSC if a reasonable alternative construction is possible. Paragraph 53 goes on. So that is the interpretation that was advanced and accepted by that court, in contrast to the arguments that have been made on behalf of Mr Hlophe, or Judge Hlophe as he then was. And that interpretational argument was ultimately resolved against Dr Hlophe as he now is. And it was resolved in those terms by the court. So the full court, my lord, has ruled that one has to avoid paralysis by the JSC, and that you have to avoid paralysis by an interpretation that avoids the impossible. And Dr Hlophe's arguments today, with great respect, my lord, seek to paralyze the JSC. Not, as Mr Bishop pointed out, not to seek an order that he can return to the JSC, but that the JSC en bloc cannot sit. And my lord, that is paralysis exemplified. And in that context, my lord, you've got to ask this question. The JSC knew that the request that was being made of them in the letter by Dr Hlophe and the MK's attorneys was to effectively have paralyzed the next week, and who knows for how long. And they looked at the interpretational points. They say so in the letter, 178, and they said, we're going for a different approach. And then the only question from the Lord is it a rational one? And we would say with great respect, of course it has to be rational. They've got in their favor the judgments which I've just highlighted for my Lord. They know that these very arguments were debated in the court at a full length. And they know that the court ultimately came to the conclusion, as it did in paragraph, I think it was 56 that everybody's read from the Western Cape judgment more recently, where in the end the court said at paragraph 56, I think Mr Manetchi quoted it, the absence of Dr Hlophe on the JSC would not be significant. There would still be 5 NA members represented on the JSC, constituting a majority of such members. That's the point. So, my lord, the first point we can summarize is the following. There would be, through the interpretational arguments that our learned friends for the applicants propose, my lord agreeing with them and paralyzing the JSC against the binding authority that I've highlighted for my lord. But my lord doesn't need to be concerned about that, because the only question before you is the rationality of the JSC's decision in any way justified? And for all these reasons, of course, it has to be justified. It would have been thoroughly irrational for the JSC to have done the opposite. My lord, just posit this. The JSC says, thank you, we take your letter. We know we've spent all this money. We know all these people are coming. We know that there is a huge demand for judges to be obviously appointed to ensure the backlogs in the courts are fixed. We know all of that, but we're going to nevertheless adjourn. That would have been thoroughly irrational. So, my lord, with great respect, there are no good reasons that have been advanced by our learned friends. There is a second point related to this, and it's the question of jurisdiction. We say this with respect to my lord, but until Dr Hlophe obtains a court order overturning the interim interdict that has been granted by the Western Cape High Court, until he obtains that order overturning it, or he wins on appeal, or he wins in Part B, he is interdicted. Full stop. My lord's point is the brute force of that order. And he cannot seek from my lord to undo that order, because it's binding on him and it's binding on my lord. As an order, orders of courts bind everybody. They bind my lord as well, section 165.4 and section 165.5. So, my lord, if he wishes to undo that, he has a remedy. My lord doesn't need to feel as though you've locked him out of court and that Section 34 rights have been violated. His remedy lies in Section 18. He can go to the Western Cape High Court, the court that granted the interdict against him, effectively, and say and immediately allow for that order to be suspended, if that's what he wants to do. There's been a debate about 18.2, 18.3, my lord. I don't want to take you back to that, other than to highlight the following, because again, our learned friend Mr Mpofu said that we've misunderstood his case, and that clearly they don't need a Section 18.3 remedy, because just by having applied for leave, it suspended the operation of the order. But my lord, that's not the position from their own letter. And some of it was read to you, but I need to take my lord to it. It's MM3, it's the letter by the attorneys.
Yes, I have
for
it.
you have it, my lord.
Yep.
And if my lord, if you go to 02-121, paragraph 5. Now these are the attorneys that are writing to the JSC, trying to explain to the JSC why the JSC must postpone next week's meetings. And look at what's said at 5. There again, at 5, they raise the 178(1)H argument, my lord. No debate. They are wanting to retread those arguments. Second, my lord, it says, the undesirable situation is exactly what will obtain unless before 7 October 2024, Part B of the High Court application or the Africa Forum application pending before the Concourt is heard and decided. That's gone away, by the way, my lord. The Constitutional Court has said no. Or the National Assembly designates another person, assuming that it's constitutionally possible to do so, which they deny. And then the outcome, my lord, of any application for leave to appeal and or proceedings in terms of Section 18 of the Superior Courts Act. My lord, on their own letter, they explained that they knew Section 18 was where they would be able to avoid what they said was that outcome. So, my lord, that's the Section 18 point. We've understood perhaps Mr Mpofu's argument incorrectly, but that is what his client's letter said through the attorney. So, my lord, let me then next say on jurisdiction that there is an insuperable further difficulty for our learned friends, and that's the judgment of His Lordship Mr Justice Olsen in my division, my lord, in Durban, Aqua Transport. My lord, in that case, there had been a review, and excuse me, there'd been a review, it had been successful. There'd been a decision to apply for leave to appeal against that review's decision. There was then a separate case which was brought for an interim interdict. So the review had been before His Lordship Mr Justice Hlophe. There was a separate case brought for an application for an interdict, but like before my lord, for an interim interdict pending the outcome of that appeal. That is effectively what His Lordship was dealing with in that case. And His Lordship Mr Justice Olsen refused it on the basis of the analysis that I don't know if you've had time to have a look at, my lord, but it's in our heads of argument. I'd ask you to take a bit of time there. It's at paragraph 25 of the heads of argument that Freedom Under Law filed.
Yes, thank you on that.
So, my lord, if I can just take you to the paragraph before that, because that it's situated. Olsen J refused to do so on the basis that, given the extant judgment against the applicant had failed to prove any right to the interdict. He explained, I find it difficult to conceive of a circumstance which throws more serious doubt upon a claim that prima facie proof of the existence of a right has been established than the fact that the court has already adjudicated, in that case finally, upon the matter, determined that the right doesn't exist. But then, critically, next paragraph. Having made those observations, I still find myself in difficulty with the proposition that this court, sitting otherwise than as an appeal court, has the power or discretion in effect to overrule, or at least to second guess, a prior decision of this court in order to grant a temporary interdict pending appeal. And he said he wants to turn his face against that. Why? Because the practice or procedure which involves, like my lord, another judge, deciding the quality of prospects on appeal before the judge who heard the main case has decided whether the threshold of reasonable prospects of success on appeal is met, undermines Section 17 of the Superior Courts Act. He says that section carefully reflects the balance. And then you'll see the bolded point next. In my view, unless the application for the interdict is brought before the judge who made the decision subject to appeal, a glaring error on the part of the original judge must be apparent in most cases before interim relief is granted. Otherwise, there'd be nothing short of a whole re-hearing that would be required. My lord, as we say...
Nothing in this case requires me to go into the full court's decision-making or criticise it or approve it in any way.
No,
And the question is, what is the effect of the order?
Yes, yes, but in order to get to whether the order has that effect,
Yeah.
there is the debate about rationality.
Yes.
And that debate engages
Well,
the very debates.
the question of rationality is, did the JSC properly apprehend the effect of the order?
Yes, but in order for that to be answered, then we get back to the debates about whether it was properly understanding the interpretation of Section 178 and the debates that we've been having about those
I'm not sure
judgments.
that's right. I mean, the fact of the interpretation is different from its correctness.
Yes, but
So if one, the question is, there's the decision of the full court. Its order has to be interpreted in light of its reasons.
yes,
Those reasons are presumed to be correct
yes.
in order to interpret the order.
Well, my lord, you've put it perfectly, except you are being asked by the applicants to presume that it is not correct because of their arguments, which are the very arguments that were raised by them there but rejected by that court. That's the conundrum. So, my lord, the moment that position is clear, that my lord accepts the reasons as being correct and that those reasons justify the order, then there's no room, and this is the point. It's the same point with great respect that Justice Olsen was, I think, putting. There's no room for another court to have to go through that process.
As I understand the applicant's case, their case is there are two ways the JSC can comply with the order, a rational one and an irrational one. They say the rational one is to postpone all proceedings
Yeah,
until the interim order is confirmed or discharged.
yeah.
JSC differs, and that's the terrain on which we're having the argument, I think.
I think that's correct.
Yeah.
And for the reasons that I've given, my lord, if that is the approach,
Yeah.
then these are the other difficulties, if I may say. My lord
Yeah.
doesn't need to get into these difficulties,
Yeah.
but they arise unless one focuses on exactly what my lord has said.
Yeah.
That's with
I mean,
respect, that's...
given the time
Yes.
that I have to decide this case, I think the shortest distance between 2 points is a straight line, isn't it?
Wilson's razor, my lord.
Sorry?
Wilson's razor.
Yeah. Well, I mean, call it what you want, but it just seems to me that I have what's been placed before me is a very narrow question of whether or not the JSC rationally exercised
Yes.
its power to refuse to postpone next week's and I think the week thereafter's interviews, and that narrows down the focus or the squint with which I must regard the full court's decision.
Yes.
The decision is not a disquisition with which I have to have a Socratic dialogue. It's just a fact. It's just there,
Yes.
and I must and I must put myself in the position of the JSC when it had regard to the fact of that decision.
Absolutely. And, my lord, the question of whether the JSC's rationality arises from its understanding of what the court had decided
Yes.
in light of the debate around 178.
Yes.
My lord,
Yes.
we're on the same page.
I mean, of course, if the case was that it completely misconstrued what the judgment and the order meant,
Sure.
but that's different from disagreeing with it, or criticizing it, or affirming it.
Yes. But a component of the rationality, and this will be my last submission on this, is whether it was appreciating what the alternative arguments were, and they are there in the letter. They knew it had been debated, and it was then asking itself, well, what is the alternative?
Yeah.
And that is the debate that it ultimately decided on a rational basis was in favor of
Yeah.
effectively agreeing with the internet. So
Yes,
my lord
thank
is...
you. I have
is
that
also-
point, yeah.
Yes, my lord. So then, in that context, my lord, we say that the next important issue for my lord to consider, and I needn't be long on this at all, is constitutional harm.
Yeah.
And I don't need to be long on it because my lord has written the Nyazi Rail judgment, and we are aware of that.
Yes.
And we've cited it for my lord in the heads. But my lord, we see the constitutional harm as being particularly important. It goes, we heard the debate with our learned friends, and we agree with you, my lord, it's a debate about where this constitutional harm fits. And it fits in two ways. It fits in, if it's an interim interdict, of course it fits in there at the outer level. But it also fits into the debate, we agree, on what is a just and equitable remedy if
Yeah.
my Lord were to have to go there.
Yeah.
So, my Lord, we say that there are, we've identified 5 harms. The first harm is a critical one, is that it's the rule of law itself which requires, obviously, that the judges be permitted, or the JSC rather, be permitted to fill the spaces, not just for the sake of filling spaces, but in order to ensure the constitutional end itself of the Bill of Rights being protected by judges who fulsomely are able to do so. The second harm, obviously, is for everybody that's having to come there but now can't, from the Chief Justice to the Judges President and so on. The third harm, my Lord, is, of course, the public resources that have been squandered. And the difficulty of trying to have these meetings. It takes months to set them up. We've heard the argument from our learned friends, well, it can be done just another 2 or 3 months and it can be sorted out. Well, firstly, that's not the relief they're seeking. But in any event, it's simply not appropriate. There's no evidence of it, but the public evidence that we're all aware of is that it takes very months. The fourth is the administration of justice. And here, just on the evidence, my Lord, there is an insuperable difficulty for our learned friends on constitutional harm. Because Dr. Hlophe doesn't begin to address the irreparable constitutional harm at all. He doesn't do so. Versus the evidence that you've got, we all referenced earlier Mr Hlophe's affidavit. But if one looks at that affidavit, he personally says, my Lord, that he collated the evidence regarding the impact of the intellect on the functioning of the courts, specifically the Supreme Court of Appeal, the KwaZulu-Natal Provincial Division, the Land Court and the Labour Court, by directly engaging with the heads of those courts. So my Lord has that evidence from him through those judges. And my Lord, it's not a case of him creating an extra reason. The reasons are given. The JSC is providing you an explanation for why it thinks its reason was absolutely right. And it had already said that it wanted to continue on this basis.
Yeah.
So my Lord, those are submissions on constitutional harm, and they will weigh in the balance heavily, we say, with respect. My Lord, and then finally, on costs. And my Lord, we are not in the fortunate position of the JSC, who can be magnanimous, because as you'll have heard from Mr. Bishop, the DA has asked for punitive costs, and Freedom Under Law does so as well, my Lord. And they've been scandalized in this case, my Lord. Your Lordship knows that after the MK party and Dr. Hlophe were unsuccessful before the full court, they didn't seek urgent legal redress. Lord, what they did is they published the media statement. And that media statement, Lord, is for my Lord's benefit. It is
I've read it.
06235.
Yeah.
The statements that are made in there, my Lord, are scandalous, obviously, and they go to the very heart of the idea that the judgment is something sacrosanct and to be respected. And with great respect, we say that as a result, there are numbers of provisions of the Constitution which are immediately implicated. Not least of all because Dr. Hlophe is a member of Parliament, he's the deputy leader of the MK, he's the parliamentary leader, and of course, we know then that those obligations on him are 165 and 173 of this court's powers to protect itself from such conduct. And my Lord, the difficulty is that we're not making, it's not just the content, it's not just statements that have been made in that media statement. It's the fact that it's a continuation of the same conduct that has been deprecated by the Constitutional Court. And my Lord, in the answering affidavit by Freedom Under Law, but to take you there very briefly, it's at 06204, paras 27 to 28.
06204.
Yeah.
Yeah.
What happened there is, as my Lord recalls, the contempt case, and then after the Constitutional Court issued its judgment, statements made by Mr. Zuma. And the Constitutional Court said those media statements were put before it. They were recorded that it was admissible evidence, and it said this at paragraph 27. If the publication of these statements had no relation to him, he could have provided an explanation, either publicly or in these proceedings. He didn't. He even had an additional opportunity to dispute his connection to these statements after the hearing of the matter. However, to date, he has made no attempt to distance himself from those statements.
There's a letter asking, I think, Dr. Hlophe and Mr. Zuma to disassociate themselves from that.
Absolutely.
Press release, is there?
There is, my
Yeah.
Lord. So there was a letter written by my clients to their attorneys, the attorneys for the applicants, saying to them, this is a statement that's been put out. It says these things about this judgment. And we would want confirmation as to whether you associate yourself with it. Now, my Lord, what you have, and in light of that passage I've just read to you from the Constitutional Court,
Yeah.
saying, you have the replying affidavit that was filed and that came in, I can't remember if it was at 12 o'clock or 2 o'clock this morning. paragraph 31
I've
of
already
it.
made clear what I was doing at 2 o'clock in the morning. Yeah.
Paragraph 31 of it, my lord, says
Yeah.
this. So, my lord, there's a further waving away of this. It says the long diatribe. It was a long diatribe. It just happened to be a very long statement. The long diatribe about alleged abusive process is disputed, and it's not worth the paper it's written on. It constitutes diversionary tactics which have no place in such proceedings. Well, of course they do when they are scandalous of the court and of your opponents. Then it says the letter marked FUL2 was unfortunately missed and will be responded to in due course. But then here, my lord, the final paragraph. Suffice to state the obvious, that neither Mr Zuma nor Dr Hlophe are part of communications. The statements are always attributed to their authors. The witch hunt is therefore misplaced and misdirected. What there is not, my lord, is a paragraph consistent with what the Constitutional Court had said against at least one of the applicants.
Yeah.
Distancing themselves from the statement. Nothing. So, my lord,
Your answering papers seem to suggest that the application should be dismissed toto as an abusive process.
no.
Now you're saying that this is relevant to costs.
It's relevant to costs as well as to the discretion that my lord can exercise.
Yes. In relation to the declaratory.
Of course.
Yeah.
So it's in relation to declaratory, and it's, well, there are three places it's relevant. It's obviously costs, it's obviously declarator, all declarators are discretionary, and it's also in relation to the interdict, because my lord knows the case law that an interdict, even considering all the other factors for an interdict, a court can always take into account the questions of abuse of process in deciding whether to grant it. So, my lord, in those circumstances, we do ask for attorney and client costs, and the costs of 2 counsel. And I'm afraid to say I haven't read the luminous judgment about on the scale C, B, or A, but whatever the right scale is that
Luminous
accommodates
or
it.
voluminous?
Luminous.
Oh. Might be voluminous as well, who knows? Yes, just on costs. You say that the attitude displayed to the full court's decision
Yes.
was scandalous and scandalous in the sense that it constituted a contempt.
Well, scandalous against.
Well, scandalizing the court is it a form of contempt?
Yes, my lord.
Yeah, I
Yes.
thought it was.
Yes.
And you say that that means a punitive costs order in this case should be made. That's
Yes.
that's the level of the submission. Is it?
That is it, my lord.
Mm.
My lord, we're not seeking to hold anybody in contempt or asking my lord to do so, but my lord cannot ignore. You sit in the same judicial branch of government as the judges in that division. You know what the case is about. It's clear before you that this statement has been made by the same parties that are now saying this of the particular judgment. And my lord, it's not that it was a scandalizing statement directed at the judges.
It was pretty clear it was about all judges, wasn't
Absolutely.
it? Yeah.
Blatantly political judgment of this court in respect of
I just worry
the
about
judiciary as a whole.
I just worry about deciding to attach penal consequences. Sorry,
We're not
penal
asking for quite that, my
just,
lord.
just forget that word. I worry about attaching punitive, that was the word I was groping for, consequences to an exercise of expression that may or may not constitute contempt of court outside the context of a contempt of court application. This is a highly political case where the applicants are deeply frustrated, I think would be an appropriate word, that the person they chose to sit on the JSC has been temporarily stopped from doing so. And they set this case up as a clash between those democratic rights and the Western Cape, well, the full court's decision to limit them, albeit temporarily, in terms of its decision. So against that background, there's a political ferment And it's in that context that the press release was made. Now, the press release may well be contemptuous. It's certainly extremely strident. And Dr Hlophe and Mr Zuma may well, on the Constitutional Court's decision, be contemptuous in failing to disassociate themselves from it if they ultimately do. Ought that not to be the focus of a much more careful inquiry at the appropriate stage? I've had this case for 48 hours, and I'm being asked by you to say, well, I'm going to make a punitive costs order against Dr Hlophe and against a party which is the official opposition in the National Assembly, largely because they said some nasty things in a press statement. That may well be turn out to have been unlawful and contemptuous, but there is a difficult underlying question there about the barrier between contempt of court, the exercise of free expression in a political context. Must I determine those issues in this case?
My lord, we would say with great respect, yes. First is it's before you. And you've got the evidence that has been asked of Dr Hlophe, and then by the letters and the response that I've taken you to. So, my lord, you've got the evidence, one. Two, you've got the Constitutional Court authority in exactly the same situation. And in that case, my lord, I want to double check the authority. I will, while my learned friend is arguing. I recall that that was one of the reasons why the Constitutional Court said, not because of contempt of court, but because of that statement that the court was going to, also as a court of first and final instance, by the way, issue punitive costs.
Yes.
And my lord, the third thing is that it's not only the political nature of the context. Political contestation is always heated nowadays. It's the question of what is said about the courts and about your opponents. About the courts, it's not just the judge in question or the judges, it's the judiciary. But then about your opponents, they are racists, they're masquerading, white malarkey.
Yes, I don't want to be understood in any way as condoning those remarks. I don't. On the face of them, they seem to be well, it would have been better if they weren't made. But the question before me isn't whether those remarks are good or bad. The question is whether particular legal consequences should be attached to them in the context of these proceedings.
Yes.
Yeah, and I think you've made your submissions.
I've made my submission. I'll finish by saying this. My lord has always, in every case, got to decide the issue of costs.
No, absolutely.
But these are the factors that go into the mix for my lord.
But the ordinary costs decision is much easier, normally. It's who won, was a constitutional issue raised, or has anybody misconducted themselves before me? Those are the usual costs inquiries. What you're asking me to do is take into account something at the periphery at best of that, perhaps even beyond that periphery, that involves penalising someone for the exercise of free speech, potentially. Perhaps it will be appropriate in due course for whoever was responsible for that statement and whoever failed to disassociate themselves from it to be appropriately penalised. I just wonder whether it's something that's appropriate to take into account at this stage.
Well, my lord, we've made our submissions.
Yes, and all I'm doing is opening my mind to you, just in case you want to try and change it a bit more.
I've given you my arguments, as trenchantly as I could, and we stand by them.
Yeah.
Thank you.
Thank you. Mr Ngolwana, is Mr Ngolwana going to reply first, or are you?
My lord, no, but if you can just make a request, Mr Ngolwana may or may not address the court, but Mr Ngolwana has asked me to make a request for a 5-minute break, and I'm conveying it because I might be the beneficiary of whatever he wants to decide.
Right, okay. Well, Mr du Plessis was well within time. So literally a 5-minute break, 2:45.
Literally.
Yeah.
Thank you. That's correct.
Thank you.
You're going to be